Welcome to the Common Law Rights Society. We appreciate you stopping by. Please like and subscribe before we get started. We hope you enjoy the reading of WEISS'S Concise Trustee Handbook, a guide to the administration of an express trust under common law, functioning under the general law merchant, by Carlton Albert Weiss, Part 2, Chapters 4 through 6. Let us begin. Chapter 4, Express Trusts under the Common Law. Section on express trusts under common law begins. The most comprehensive definition of an express trust is found in earlier case law and has been eloquently summarized by Alfred D. Chandler Esker in a report submitted to the Massachusetts Tax Commissioners. According to Chandler's report, an express trust is a structure where the legal ownership is placed entirely with one or more trustees, while others hold beneficial interests in the trust. These beneficiaries, however, are not considered partners or agents of the trust. This arrangement is a straightforward common law right that any legally competent person or group of individuals may exercise without requiring privileges from any outside authority. Trustees can issue certificates of beneficial interest, divided into shares, and handle trust assets as freely as they might open a bank account or manage personal finances. Footnote 9 reads, Alfred D. Chandler Esker, Express Trusts under the Common Law, a superior and distinct mode of administration, report to the Massachusetts Tax Commissioners on Unincorporated Associations, 1912. Footnote 10 reads, Black's Law Dictionary defines a person sui juris as someone fully capable of managing their own affairs without legal disability or guardianship. See Black's Law Dictionary, 1st edition, page 1135. Creating a trust. When creating an express trust, it's essential to understand that the structure operates as a private contract for holding a divisible property interest. The settlor empowers the trustee to manage assets for the benefit of the beneficiaries without needing approval from outside parties or institutions. In other words, whatever a person may lawfully do for themselves, they may authorize a trustee to do on their behalf. This structure does not require any external privileges and thus remains separate from governmental oversight, provided it does not involve any criminal or civil wrongdoing. Footnote 11 reads, Harwood v. Tracy, 118 Mo. 631 24 SW 214 216, Shaw v. Payne, 12 Mass. 293. Footnote 12 reads, Hale v. Henkel, 201 U.S. 43 74, 1906. Declaration of the Express Trust. Continued description of the Declaration of Trust. The Declaration of Trust is sometimes called the trust indenture because it outlines the trustee's duties and powers. A declaration of trust does not require technical expressions, as long as the settlor's intent to establish the trust and benefit specific individuals is clear. In constructing a valid express trust, the declaration should include details about the objects of the trust, the property it holds, and the precise method of its administration, expressed in clear language. Any lack of clarity in this intent could lead to equity interpretation, which may invalidate the trust depending on the degree of ambiguity. Footnote 13 reads, Lawson on Contracts, Section 294, page 381, 3rd edition, 1923. Footnote 14 reads, Berry v. McCourt, 204 NE 235 240, 1965. Chapter 5, The Trust Corpus. Section on trust corpus begins. The trust corpus, also known as the trust body, refers to the property being held in trust for the beneficiary. This corpus can include almost any form of property, although certain types of property may be better suited as trust assets based on their legal characteristics. Historically, express trusts in the United States were first used to address difficulties in obtaining special corporate charters for real estate holding companies. Known as Massachusetts Land Trusts, these trusts later expanded to include personal property holdings. The relationship between law and land is a fundamental principle, especially within the context of the common law. Historically, land ownership required a unique legal framework, which often made it difficult for statutory entities to hold land. In an express trust, the trustee has in rem jurisdiction over the trust corpus, meaning they retain possession of the property unless they voluntarily surrender it. Footnote 15 reads, John H. Sears, Declarations of Trust as Effective Substitutes for Incorporation, Section 1, page 4, 1911. Footnote 16 reads, Lee Brobst et al., The Law, the Money, and Your Choice, available at the Republic website, last visited January 8, 2007. In America, without the 14th Amendment, the law of the land remains the Constitution, along with its principles of common law. By holding real estate or precious metals, an express trust continues this bond between law and land, thus preserving certain legal protections that come with it. Footnote 17 reads, See the Constitution for the United States of America, Article 1, Section 1017-89. Chapter 6, Certificates. Section on certificates begins. One unique feature of a trust is its ability to divide the trust property into shares and issue certificates. This capability is not limited to corporations. In fact, trustees of express trusts are authorized to issue certificates of beneficial interest and capital interest without needing a corporate charter. Beneficial interest is usually held by the beneficiaries, who are entitled to a proportionate share of the trust's assets. Capital interest, on the other hand, is typically held by investors who contribute property to the trust and are thus eligible to receive a share of profits or assets upon the trust's termination. Control test. The classification of a trust can depend on the level of control held by the certificate holders. If the trust certificate holders maintain control over the property and administration, it is likely a partnership instead of an express trust. In express trusts, ultimate control must rest with the trustee. Courts of equity refer to this as the control test, which states that a trust is only an express trust if the trustee maintains full control over trust property. Beneficiaries in this case are neither agents nor partners, which limits their liability for any debts the trust may incur. Footnote 18 reads, Bank of America National Trust and Savings Association v. Scully, 92 F. 297, Circuit Court of Appeals, 10th Circuit, 1937. Footnote 19 reads, Rand v. Morse, 289 Fed 339, Circuit Court of Appeals, 8th Circuit, Missouri, 1923. Furthermore, certificates of interest in an express trust generally lack fair market value, so no gain or loss is recognized until the cost basis of the property has been fully recovered. Courts have long held that certificates serve as documentary evidence of ownership and intangible rights, but are considered personal property rather than actual shares of ownership. Footnote 20 reads, Commissioner of Internal Revenue v. Marshman, 279, F2D 27, Circuit Court of Appeals, 6th Circuit, 1960. Footnote 21 reads, Joseph H. Beale, The Exercise of Jurisdiction in Rem to Compel Payment of a Debt, Harvard Law Review, Volume 27, page 107, 1913. End of Chapter 6.
So daily discipline and faith that is consistent, tilling of the soil for the fruit to be abundant, seeking out the wisdom, always be a student, watering the root and bringing forth the remnant. Now who you want to be, which choices will you make? The path of destiny are the choices that we take, and you can start again, and now you're in the wake. Keep intact your vessel and clear the muddy lake. The wise will recognize, realize, prioritize. Get your mind in order, you have to supervise. Vigilant with love, we have to synthesize. Now wise as a serpent, Jaloving is the prize. So daily discipline and faith that is consistent, tilling of the soil for the fruit to be abundant.